Okay, great. Thank you for coming. Welcome to the Patent, Trademark, and Copyright Toolkit class, which is an introduction to intellectual property, or IP. As a bonus, we're also going to be including the fourth lesser known type of intellectual property called trade secrets. Hey, I'm Cheryl Overheiser, librarian and representative of the Patent and Trademark Resource Center, or PTRC, at the Free Library of Philadelphia, and past fellow at the United States Patent and Trademark Office, or USPTO, from 2017 to 2018. We have some acronyms, but not too many, and so there'll only be about 3 or 4 for you to remember. I'm joined by my co-host, business supervisor, and BRIC department head, Jillian. Thank you, Jillian. We're going to be recording this presentation, as you heard, and we're going to send the recording to you, plus the slides after the presentation. Please put your questions in the chat, and we're going to stop after each section to answer them. As I mentioned in the last slide, the Free Library of Philadelphia is a PTRC, or a Patent and Trademark Resource Center. What is that? We are one of 83 libraries in the U.S. and its territories designated by the United States Patent and Trademark Office, or USPTO, in Alexandria, Virginia, as a resource for patent and trademark information for the public. The Free Library of Philadelphia has been a PTRC since 1986. Here's a picture of our beautiful new Business Resource and Innovation Center, or BRIC space, on the ground floor of the Parkway Central Library, where the PTRC and other BRIC services are located. The PTRC's main focus is on patent and trademark information, but we also include learning resources for copyrights and trade secrets. We provide information, but not legal advice, since we're librarians and not attorneys. The BRIC also has services for nonprofits, job seekers, and businesses, so please check us out. Let's talk about intellectual property, or IP as it's known. Patents, trademarks, copyrights, and trade secrets are all intellectual property, or IP, which are protections for what you invent or create. The type of IP you use depends on what you create. What are the 4 types of IP protect? Patents protect your inventions. Trademarks protect your business brand, like your brand name, logo, or slogan. Copyrights protect your artistic creations, like song, poems, books, blogs, photo, painting, or movie. And trade secrets protect your business secrets, like your secret sauce recipe, customer lists, production methods, also inventions, and more. So we're going to go over each one in turn. Okay, what are patents? Here's a definition with the important words highlighted. A patent is a property right obtained from the U.S. government to exclude others from making, using, offering for sale, or importing the invention for a limited period, either 15 or 20 years, in exchange for public disclosure. Well, let's break this down a little bit. The words exclude others mean that you don't necessarily have the right to make, use, and sell and import your invention, but to exclude others from doing so. So what does that mean? Let's say you have a great idea to add an eraser to the tip of a pencil, something that had never been done before. And you were granted a patent for putting an eraser on the tip of a pencil. You now have the right to exclude others from making, using, or selling a pencil with an eraser. But can you sell a pencil with an eraser? Not necessarily. Someone else might have a patent for a pencil, and with it, the right to exclude you from making, using, or selling a pencil, whether or not the pencil has an eraser. In this situation, it might be necessary to have a licensing agreement with the pencil patent holder in order to sell your invention. Also, the term of your patent is limited and can't be renewed. After the expiration of your patent, it is in the public domain and anyone can make, use, sell, or import it. And finally, you must make a full disclosure on how to make and use your invention in your patent application. So after it expires, anyone can make, use, sell, or import your invention. Okay, I see we have a question in the chat. Oh, it's Jillian. Great, thank you. Okay. There are three types of US patents: utility, design, and plant. They cover different inventions and have different requirements, coverages, and costs. All US patents are obtained through the USPTO, United States Patent and Trademark Office. You need to decide on the type of patent before you apply. Here's some examples of the three types of patents. The K-Cup invention received a utility patent in 1992, and that's the one you use in a Keurig or other coffee maker to make a perfect cup of coffee every time. This silverware design received a design patent in 2014, and the Honeycrisp apple received a plant patent in 1990. As I mentioned before, patents are not renewable. Okay. Let's talk about the most common type of patent protection, which is the utility patent, which makes up 93% of all granted patents. Utility patents protect the way something works. Here's an example of a utility patent for a drone patented in 1962. Utility patents last 20 years and cost anywhere from $790 to $3,160, depending on the size of your company and your household income. Most independent inventors will qualify for the lowest price, $790. We'll discuss the fee structure again shortly. Utility patents have maintenance fees, which range from about $3,400 to over $13,000 that have to be paid over the 20-year life of the patent. These maintenance fees also depend on the amount of household income you have and the size of your company. So note, it will take about 2 years for the USPTO to decide whether to grant you a patent. It used to be 3 years, but they're improving. Utility patents are not easy to get, and currently only 60% of utility patent applications are granted patents. Okay. It used to be worse. When I started doing this about 7 years ago, only 49% of utility patent applications were actually granted patents. A utility patent protects the invention of a new and useful process, machine, manufacture, or composition of matter, or a new and useful improvement thereof. Okay, and you must fulfill these requirements. It has to be in a statutory class, which is not that hard. It has to be a process, like a heat treatment, a machine, an article of manufacture, like a tool, composition, like a chemical composition, or the new use for something old. The patent must have utility. That means it must have be realistically useful. So you don't have to provide a model with your patent application. You used to have to, up until I think it was 1880, you had to build a little model of your invention and send that along with your application to Washington, D.C. And they would store them in kind of a museum kind of place. And people used to go and visit them. That was something you could do on a Sunday. On your day off, you could go to the patent office and look at all the patent models. That's not a requirement anymore, but it has to realistically work. So that means it can't be something like a perpetual motion machine. It has to be legal, and that means things that are illegal, like a safe cracking device or an invention to counterfeit money, would not be granted a patent because that's illegal. Okay, it has to be novel or new, and that means it has to be physically different than previous inventions, a new combination, or a new use for something old. Because of this requirement, it's a good idea to search prior art to search for existing inventions anywhere in the world. Also, you have, as an inventor, 1 year if you sell your invention or reveal it publicly to file a patent application. After 1 year, your invention is not considered new. So if you've been selling your invention for 3 years or showing it at trade shows, it likely would not fulfill the newness or novelty requirement. And the last one, non-obvious or unobviousness, is the hardest one to meet. And this is kind of like the wow factor. It has to have new and unexpected results to Fosita, a person having ordinary skill in the art. So it's the wow factor, it's the flash of genius. One example I usually use is, there was a product, or is a product, for called Bag Balm, which dairy farmers use on sore skin in dairy cows. Well, someone found that if you put Bag Balm on a bald man's head, it would help him grow hair. So the people who figured that out, the new and unexpected results, were able to get a patent using the Bag Balm formula because it helped grow hair. It was the new and unexpected results and a new use for something old. The second type of patents are design patents, which are 6% of all granted patents, so they're much less common. Design patents protect the way something looks and not its structural or functional features. For example, here's some silverware that was granted a design patent on it because it protects not the way the spoon, fork, and knife work, because they work the same as any other silverware, but rather how they look. Okay, so it sees you have these the unusual handles. It gets very thin here, and then also has these cutouts near the business end of the fork and down here. So they got a design patent for that because of the way it looks. Design patents last 15 years and are a little easier to get than utility patents. 60 to 70% of design patent applications are granted, and they also take less time for the USPTO to process, about 18 months instead of 2 years. The costs start at $475, and the fees are also based on the size of your company and your household income. There are no maintenance fees for design patents. The requirements for a design patent are similar to a utility patent. It has to be an article of manufacture. It has to be ornamental, original, novel or new, and unobvious. The rarest type of patent is the third type of patent, the plant patent, which is only 1% of granted patents. The plant patent lasts 20 years and has no maintenance fees. The fees start at $575 and have the same basis as in size of company and your household income of the inventor. This is the Honeycrisp apple, which was patented in 1990 that we mentioned earlier. The Honeycrisp apple was noted for its juiciness and sweetness. And a very early patent is here, the Haas avocado. It was patented in 1935 and was a very early plant patent. Plant patent started in the 1930s. Okay, patents are expensive and not easy to get. Plus, if you're not granted a patent, you don't get your money back. Yeah, unfortunately. The good news is there's a cheaper, easier way to get started for utility and plant patents. This is the provisional application for patent that you might have heard of. It also has a sliding fee scale and starts at $75 with a $50 processing fee. So it would be $125 at the lowest level. There are less requirements for the provisional patent application. It's good for 1 year and cannot be renewed. It'll never grow up to be a regular patent application though. So within 1 year, you must file for a regular patent application. The 1 year of the provisional patent application will allow you to use the term patent pending, which is likely to help you if you're looking for investors or trying to find a manufacturer for your product. You do need to fully disclose your invention, but there are less requirements for this filing. Okay. Remember when I said earlier that if your patent application is not granted, you don't get your money back from the USPTO, and that newness or novelty is a requirement to get a patent? Because of these requirements, it's probably a good idea to search for existing patents before you apply, because the USPTO will not issue a patent when the invention claimed is already public knowledge in some form or fashion anywhere in the world. The search for these already existing patents is called a prior art search. Prior art is kind of an odd term because it doesn't have anything to do with art, but it does have to do with the state of the art of technology of your invention, and that's why they call it a prior art. It has to do with a state of art of the technology. Free good places to start your search are these databases available on your home computer: Google Patents, ESPOSnet, and the USPTO. Okay, you can put in some words to describe your invention in the search boxes and see what comes up for existing patents. And then you can refine your search by using patent classifications. You can make an appointment at freelibrary.org/patents to get a one-on-one demonstration of searching techniques for keywords and classifications on the patent databases from me, the patent and trademark librarian. So as I mentioned earlier, substantially reduced rates for patents are available for small businesses, nonprofits, and those who qualify because of income, or if you work for an institute of higher learning, like a college or university. So you can see here, the cheapest rate, $750, is available for a micro entity, and they define that as somebody who has 4 or fewer previously filed U.S. patent applications. Neither the applicant or the inventor or a joint inventor or ownership partners has in the calendar preceding year. So that means anybody who's involved with the invention has an income equal to 3 times the median household income. So what does that mean? Currently, if your household income or anyone involved in the invention has an income less than $239,000 a year, or you have income primarily from an institute of higher learning, like a college or university, you would qualify for this cheapest rate, micro entity rate. If you don't qualify for that, you might qualify for a small entity if you're a nonprofit, or you have less than 500 employees in your company. If you don't qualify for that, you're like a bigger company, you would pay the higher amount. But like I said, most independent inventors will probably qualify for this cheapest rate. And you don't have to pay all of it once. You have to pay about 2/3 of it to apply. And then you pay the final third of this fee when the patent is issued. So you only need to come up with about 2/3 of this when you apply. Okay. Patent rights can be sold. It's called an assignment. You can rent out your patent rights for royalty payments. This is called a licensing agreement, or you can leave it to your heirs as part of your estate if it's still in force. Patent rights are only good in the US and its territories. There's no international patents. If you wish to get a patent in a foreign country, there's several options. You can apply to individual countries, like here and here, or through a cooperative program. It is quite expensive. The cooperative programs, like the Patent Cooperation Treaty, which has over 150 countries, can save you money if you're going to apply for to a lot of countries. It's kind of like the Common App for colleges now. If you only want to apply for a couple countries to have a patent in their country, say you just want Canada and Mexico, it might make sense to apply to the individual countries under something called the Paris Convention. Here's a link to some options for foreign patents from the USPTO. If you were to apply to every country in the world to have a patent for your invention, it would probably cost about $2 million. So it's quite expensive. You're probably going to want to think through it carefully and consult an attorney before you proceed. Here's a timeline comparison of the Paris or individual country method and the Patent Cooperation Treaty. The Paris Convention guarantees that a foreigner's patent application will be treated the same way as a citizen of that particular country, and that they will honor your filing date in the United States as the filing date or beginning term of your patent in your home country. They'll do it the same in theirs, as long as the filing is made within a certain period of time. And here's some countries belonging to the Paris Convention, and you can see it's really most countries in the world. And here's the Patent Cooperation Treaty. It's fewer countries than the Paris, but really a substantial amount of countries belonging to the Patent Cooperation Treaty for getting foreign patents. Okay, so we're going to stop now. This is the end of the patent portion of the presentation. So I see there is a question. Oh, it's Jillian. Thank you, Jillian, for all these helpful postings in the chat. And that's the link that you can click on and fill out a short form, and you can have an appointment with me to show you searching methods or just to ask questions. You know, whatever you need. It's 45 minutes of your time, and I'll answer questions about intellectual property, patents, trademarks, copyrights, and trade secrets as best I can. Thanks, Jillian. If there are any other questions, you know, let me know, and we can circle back. Okay. All right, now we're going to talk about trademarks, the second type of intellectual property, which protects your brand. This means your brand name or logo or slogan that identifies your business. Here are 7 different examples of trademarks. We have the term Rolex, which is a trademark for a watch company. We have the bullseye, which is a trademark for Target, the little bird for Twitter, and Starbucks with the word Starbucks coffee and the mermaid in the middle, and the slogan, "You're in good hands," which is a slogan for Allstate Insurance Company. And here's Harley Davidson, which is like a shield with specific colors and words, and Netflix. Some trademarks are words only, some have no words, and some have both, but all are trademarks. Okay, a trademark is generally a word, phrase, symbol, or design, or a combination thereof that identifies and distinguishes the source of goods of one party from those of the others. There are also some unusual trademarks like sound or scent trademarks, like the one recently registered for the distinctive smell of Play-Doh. But that's unusual. There are only about 13 scent trademarks. The most common reason for a trademark to be refused registration is a likelihood of confusion. A likelihood of confusion exists when both of these conditions, the trademarks are similar and the goods and services of the parties are related, such that consumers would mistakenly believe they come from the same source. Trademarks protect you, the business owner, but they also protect the consumer. So the consumer understands exactly who is making and selling this particular product to protect them from knockoffs, for example. So I'm going to talk about this a little bit more in a few minutes. There are 3 types of trademarks. They come from different sources with different coverages. Unlike patents, where you can only get them one place, there's 3 different places to get trademarks in 3 different types. Common law, state and federal, and they can be renewed, unlike patents. They can be renewed indefinitely as long as you meet certain conditions. Okay, the first type of trademark is the common law trademark. A common law trademark is a do-it-yourselfer and is available immediately. You just start using it. It's cheap and easy. It does have some cons, however. With a common law trademark, you could be infringing on someone else's trademark without knowing it, and they could send you a cease and desist letter in the mail and tell you that you must stop using it immediately. You might have to rebrand your company, which would cost you money, and it's possible that the owner of the registered trademark might ask you for money damages. Even if that doesn't happen, your business could get stuck staying small. Say, for example, you're selling in a small geographic area and someone else gets a similar trademark for related goods and services on the federal level, which gives them protection throughout the US and its territories. Even if you were using your common law trademark first, sorry about that, you might get stuck staying in your small area and not be able to expand. As you can see, the little TM in the upper right corner, of trademark means that you're claiming trademark rights. And you can use that if you're using a common law trademark. So you can use a common law trademark, put a little TM in the upper, middle, or lower end of the trademark and say, tell people you're claiming this as a trademark. Okay. The second type of trademark is a state trademark where you get protection at the state level. This is available in all 50 states. You can see the hyperlink here where you can locate the agency that registers trademarks in your state. These are generally cheaper than federal trademarks, but not as powerful. The cost varies from $10 to $50, and they last anywhere from 5 to 10 years. Just note that your coverage under a state trademark may not cover the entire state if you're in a dispute with someone with a federal trademark. You can use the TM designation when you have a registered state trademark showing that you have claiming state trademark rights, or you're claiming trademark rights. In Pennsylvania, currently you can get a state trademark that lasts 5 years for $50. Okay, here we have the federal trademark, which is the most powerful type of trademark. It's good in the US and its territories. It lasts 10 years and can be renewed. You can see here that there's an R in a circle that you can use if you're granted a federal trademark. So you can only use this R in a circle when you have a federal trademark, and it lets others know that you have a federal trademark. The cost starts at $250 and it's based on what you're selling. If you're selling goods and services in 2 different classes, that would be $250 times 2. You get the lower $250 cost to file if you fulfill certain requirements, such as paying the fees up front, filling out the application form completely, agreeing to correspond via email, and using an existing class of goods and services. Or if you make a mistake, they'll bump you up to the $350 price. Examples of an example of 2 different classes of goods and services might be a beauty salon that does hair. So their service would be doing hair. Let's say they decide they have developed their own brand or a line of hair care products, and they want to sell that using the trademark. That would be a different class of goods and services, and so would incur an additional fee, either $250 or $350. So if you have, I'm going to do hair and also sell hair care products, it would be either $500 or $700 or more if you're selling things in different classes of goods and services. To get a federal trademark, you must be using your trademark in commerce or have the intent to use it in commerce. Use in commerce means selling or shipping your product or services across state lines. You must also provide a specimen of use, such as a picture of your product with the trademark inside or a link to your working website. If you're not yet using your trademark in commerce or you're not ready to provide a specimen, you can file on an intent to use basis, which is good for up to 3 years, but will cost you more. It generally takes 9 to 12 months to the federal USPTO to tell you whether or not you're going to get your trademark. Okay, here's a really helpful brochure about federal trademarks. Please read it if you want to get a federal trademark. We used to have this in print, but now it's only available online, and it's about 32 pages. It's a really good resource for trademarks and easy to read. It's a quick read with a lot of good information. Okay, remember when I said that the likelihood of confusion was the most common reason for a trademark application to be refused? Before you apply for your trademark, it's a good idea to search for existing trademarks, because like patents, you won't get a refund if the USPTO does not register your trademark. You're going to look for existing trademarks that are similar in SAM, that's the acronym, sound, appearance, and meaning. Okay, for example, say this company, T-Markey, has an existing federal trademark to sell t-shirts and pants. Or excuse me, t-shirts. And then T-Markey comes along and they want to sell hats. So T-Markey, t-shirts and pants, T-Markey comes along and wants to sell hats. Even though T-Marky is spelled completely differently, it sounds the same. T-Marky and T-Marky, and so it's a two-part requirement. The products are related goods and services. So what are related goods and services? They're things that are sold in the same place. So if you go into a clothing store, they're probably going to be selling t-shirts and pants, and also hats will likely be in the store. So T-Marky would likely be refused registration to sell hats. This next one, T-Marky and T-Markly, are spelled differently but look the same, and their goods and services are related. So T-Marky with the existing trademark and T-Markly, they would likely be refused registration for their mortgage lending services. Gato and cat are dissimilar. They look different, they sound different, but they mean the same thing in Spanish and English. So if your trademark is similar in appearance and meaning to an existing trademark, and you're selling related goods and services, your trademark registration may be refused registration because of likelihood confusion. So all of these second companies here on the right, this one, and this one, would all likely be refused registration because they're similar in either sound, appearance, or meaning and related goods and services. Okay, conversely, the exact same trademark can coexist with another trademark if the goods and services are different. Here's an example using the federal trademark Fusion. Because the goods and services are so different, these federal trademarks for Fusion can coexist. The Ford Fusion automobile, the Fusion underwater vehicle, and the Fusion Internet Connectivity Company are very different goods and services and unlikely to cause confusion, even though they're spelled exactly the same. So they can all have the federal trademark Fusion. There are two different federal application forms for trademarks, the standard and the special form mark. The standard application is used when your trademark is only words, letters, or numbers. This can give you broader protection than a special form application. Once you get your standard form trademark, you can add logos or colors or change your font. You have to use the special form application if your trademark includes a design or a logo alone or with wording on it, or if a particular style of lettering or color is important. Sometimes people say, well, can I trademark my name, logo, and slogan in one special form application? You can, but they always have to be used together, okay? It's easier to get a trademark if your trademark is distinctive. So this is the continuum of distinctiveness from generic to distinctive. The USPTO principal register offers the most trademark protections. Trademarks on the principal register are distinctive, meaning they're either coined or made up names like Xerox and Kodak, they were made up. Arbitrary, meaning the original meaning of the word has little to do with the product. And suggestive means suggesting something about the product, such as ever-ready batteries, meaning the battery will always be ready when you need it when the power goes out. If your trademark is generic, it says exactly what the product is, or if it's merely descriptive, including surnames and geographic names, your trademark could be refused registration or registered on the supplemental register with less trademark rights. Trademarks that were originally on the supplemental register in the past, like McDonald's and Honey Baked Ham, can acquire distinctiveness through time, usually about 5 years. You can apply to have it moved over to the distinctive principal register and get the most trademark rights. So that's what happened with McDonald's because it was primarily a surname. The USPTO doesn't like that because if it's a surname, it belongs to other people too. But after 5 years, McDonald's became successful and acquired distinctiveness and are now on the principal register. Same with honey baked ham. It said just what it was. It was ham baked with honey. But after 5 years, they were able to move over to the principal register. Generic, if you're trying to get a trademark that says exactly what you're selling, like you're selling apples and you want to get a trademark for the apple shop, you would likely be refused registration. You also have to police your trademark. I mean, unfortunately, you spent the time and the money to apply, but you have to police your own trademark. This surprised me a little when I started doing this. I thought that the Patent and Trademark Office would police a trademark, but no, you have to do it yourself. And that means that you have to check the weekly Trademark Gazette for new registrations, Google your trademark periodically to see if someone is infringing on your trademark. And these two products did not. The company that had a federal trademark for aspirin and the Lyft company, this was a federal trademark for elevator. They didn't police their trademark. They fell into common usage. So now it's no longer available for a federal trademark. Okay. This is a screenshot of the trademark landing page at the USPTO. There's lots of help here with videos and tutorials to help you before you apply for your trademark, during the process, and once you receive your trademark. So they really give you a lot of help with the whole process. Okay. I'm going to talk about business names, trademarks, and domain names. These three things are not necessarily the same because they come from different agencies. A business name is registered with a state agency, such as the Pennsylvania Department of State, or registered with state or federal agencies. Domain names are registered with an accredited domain name user like GoDaddy or domain.com. Trademarks are also registered with state agencies, like I said. So business names, trademarks, and domain names are registered at different places. They could be the same, but not necessarily. Like the example I like to use is for Subaru, which was a trademark for a certain type of car. But at that point, when it was first trademarked, it wasn't sold by the Subaru company. It was sold by Fuji Heavy Industries. So the business name and the trademark were different. Another example is Kellogg's, which was also, the business name was Kellogg's, so they were the same. And also the trademark might be the same as the domain name, but not necessarily. So if you get a domain name, you should check and make sure that it's not a registered trademark for another entity. So if you're able to get a domain name, it doesn't mean you necessarily can use it. There might be a trademark problem. So please, it's a good idea to check it out. All right, just like patents, there's no international trademarks. If you want to get foreign trademark protection, you can do it through a cooperative program like the Madrid Protocol that has 109 countries that belong to the treaty. Here's a little calculator to see how much it will cost. There's also, you can apply to the European Union, which has 27 countries. And that's, a cooperative program to make applying to European Union countries cheaper and easier. Because of Brexit, you do now have to apply to the UK separately at uk.gov. Government, let me see. If you're only going to apply to a few countries for a trademark, you can apply to the individual countries under the an international treaty. Or you can apply through a convention. So here it is, the EU, you can apply, the Madrid Protocol, and also under the Paris Convention, you can apply to different countries. Let me see. One of the main things you're going to be doing when you file for a foreign trademark is they're going to check and make sure that it doesn't mean anything offensive or demeaning in their own language. One of the examples that usually used is the car with the trademark Nova. in the 60s and 80s. So if you're older, you might remember it. My dad had one. Unfortunately, in Spanish-speaking countries, Nova means it doesn't go, which is not a good name for a car. The Nova did not do well in Spanish-speaking countries because nobody wants a car that doesn't go. Another thing to be aware of is that other countries may not require use in commerce like the United States does, so they might not be able be required to be actually using it, as is a requirement in the United States. This can be a problem because if your product becomes very successful in the United States, people in a foreign country where use in commerce is not required may register and gain rights over the use of the name that you might be wanting to use in a foreign country. You might have to pay them to get the rights to the trademark, and likely it would be more than the normal fee, or find a different trademark to use. Also, just like patents, you may be required to hire a local attorney to get a foreign trademark. Usually, if you talk to a US attorney, they can recommend an attorney in a foreign country that they may have worked with. An example of the same product, different names, is in the next slide. Okay, so here's some US products in other countries. What we know as Lay's potato chips are called Walkers in the United Kingdom. I'm not really sure why. Maybe Lay's was already used for another product. Here is Hungry Jack's in Australia, which we think of as Burger King, but they're Hungry Jack's in Australia. And they also seem to use the term brekkie for breakfast, when I didn't realize that before. And then here's Mr. Clean. And in Germany, it's known as Meister Proper. Okay, so Meister is like Mr. and proper is a like kind of a term they use for clean and neat. You can search for foreign trademarks at these three databases that can show you trademarks around the world to help you with your research before you apply. And also here is a map of the countries that follow the Madrid Protocol. They're marked in green, so you can use the Madrid Protocol Treaty to apply to multiple countries for a cheaper rate than you would if you filed individually. So do we have any questions about trademarks before we move on to the next thing? Okay, that's fine. I'm going to keep going, but put a question in the chat if you have one. Okay. Here's the third type of intellectual property, copyrights, which are handled by the Copyright Office, which is part of the Library of Congress. So unlike other countries where there's one office to handle all types of intellectual property, the United States has it split up. Patents and trademarks at the USPTO, copyrights are handled by the Copyright Office, Library of Congress. And it is copyright.gov to go to it. Copyrights protect artistic works like poetry, books, songs, plays, pantomimes, photographs, sculptures, motion pictures, sound recordings, and architectural works can be covered by copyright. Copyrights are cheaper than patents or trademarks. The cost starts at $45, and it takes about 3 to 9 months to receive your copyright. The copyright term is generally the life of the author plus 70 years. Works created before 1978 or work for hire will have different copyright terms. Copyright is a form of protection grounded in the US Constitution and granted by law for original works of authorship fixed in a tangible medium of expression. Copyright covers both published and unpublished works. So let's break down the copyright definition. An original work of authorship is a work that is independently created by a human author. So that means things that were created by robots cannot be covered in the United States by copyright. It has to possess at least a minimum degree of creativity. Things that have a minimal degree of creativity are things like photographs, paintings, books, and blog posts. Things that do not possess a minimum degree of creativity are things that are merely lists, like a phone book or a recipe. Unfortunately, a mere list of ingredients is not considered to possess the minimum degree of creativity required. So you likely can't copyright your biscuit recipe. However, a collection of recipes in a cookbooks will likely receive copyright registration. Okay. I see we have a question. I'll see what it is. Does literary work include nonfiction like a workbook? Yes, good question, definitely. Okay, a work is fixed when it's captured in a sufficiently permanent form that the work can be perceived, reproduced, or communicated for more than a short time. So what does this mean? This means a recording, audio or video, something that's in print, saved in a computer file, a drawing. There's even a movement notation that can record choreography. Writing in the sand or singing your original song in your car is not considered a tangible medium of expression. Copyright protection in the United States exists automatically from the moment the original work of authorship is fixed. You don't have to apply for copyright registration to have copyright rights. Here's an example of a copyright notation that you can use to show that you're claiming copyright rights even without registration. So it's a C, the first year of publication, and your name. All right, so if I get all these rights when I fix my creation, why should you bother to register with the Copyright Office? If you register your copyright at copyright.gov, there will be a public record of your ownership, and you will be able to file for an infringement case in court. Registration will allow for damages, attorney's fees, and costs to the copyright owner. And you can file also with the U.S. Customs and Border Patrol protection against people importing any counterfeit materials of your copyrighted work. To apply for a copyright, go to copyright.gov. Here's the home page for copyright.gov. If you hover over law and policy, law and guidance, there are circulars that are helpful, 3 to 4 page guides on every part of the copyright process. You can click on registration and go to the registration portal to find sections for 6 different types of copyright that you can apply for. There's helpful videos and tutorials to help you in the process. It's less expensive and faster to apply online than by mail. You can apply by mail, but it's going to cost more and take longer. They want you to apply online, and you will get the answer on your copyright much more quickly doing it online. Just like patents and trademarks, there's no international copyright per se, but treaties can help you protect your copyright rights in foreign countries. The Berne Convention has 179 countries in it, and they honor other countries' copyrights with certain minimums. And notably, you don't have to have actually registered the copyright in your home country to be eligible for this protection. You only have to have it fixed in tangible form, which is pretty cool. So you can have copyright rights in foreign countries, even if you haven't registered it in your home country, as long as it's fixed in tangible form. Some of the countries in the Berne Convention don't protect for the life of the author plus 70 years. Some only provide it for the life of the author plus 50 years. So you need to check the country's laws that you're interested in. There's a really helpful circular at copyright.gov called Circular 38A, International Copyright Relations of the United States, that you might want to look at. So you can go here to circulars and look for that one about international copyright relations to find out more about foreign country copyright. And here is a map of those countries that are a party to the Berne Convention, and you can see it's many, many, many. Okay, all right, so this is the end of the copyright section. Does anyone have any questions? Okay, I'm going to keep going. All right. So last but not least are trade secrets. Trade secrets are business information that gives you a competitive edge over other businesses. The cost is free and it's a do-it-yourselfer. People ask me, where do I apply for my trade secret? And I say, you don't apply anywhere because it's a secret. Trade secrets are good protection for things like your secret sauce recipe, since you're unlikely to be able to get a patent or a copyright on your secret sauce recipe, your biscuit recipe, or your chocolate chip cookie recipe. Here are the steps for trade secrets. First, identify your trade secrets, which could be a device, a formula, method, pattern, program, process, or technique, or even an invention. Secondly, you need to take reasonable steps to keep your trade secret confidential, such as keeping it password protected or locked in a safe. Only those employees who need to know the trade secret should have access to it. So don't leave your secret sauce recipe pinned on the staff bulletin board. You may want to ask your staff to sign non-disclosure agreements so that they understand if they reveal your trade secret to a competitor or try to sell it, or take it with them when they go to work for one of your competitors, they can be sued in state or federal courts. Trade secrets never have an end date, so some companies may consider using them instead of patents. However, be aware, unlike a patent, competitors may reverse engineer your secrets and you're just out of luck. Here's an example of a trade secret. It is Alina Blackburn baseball rubbing mud, which is used by every major league baseball club. All new baseballs are rubbed with this river mud, which is harvested somewhere along the Delaware River near Philadelphia. The exact location of this magic river mud is a trade secret. Other famous trade secrets are the Listerine formula, the Google algorithm for displaying results on its results page, the recipes for Big Mac sauce, Mrs. Field's cookies, Coca-Cola, WD-40, and Twinkies. Okay. Fortunately, there is protection for trade secrets in foreign countries, and it's called the TRIPS agreement, that stands for Agreement on Trade-Related Aspects of Intellectual Property Rights, or TRIPS. Countries that are party to this treaty have agreed to protect your trade secrets under their laws as long as some requirements are met, which is pretty much what the trade secrets requirements are in the United States. And here's another nice map of the companies that are party to the TRIPS agreement. If you want to get more information about intellectual property, please sign up for our other resources. Jillian shared some links about how to get in touch with us. We have one-on-one appointments with librarians, office hours with legal professionals, and more classes. So what about an attorney for your intellectual property protections? You don't have to get one, but if you want one, you can explore these legal resources in the Philadelphia area and beyond. Okay, if you're going to use a patent attorney or a patent agent for getting a patent with the USPTO, they have to be registered. And this is the link to find registered patent agents and patent attorneys. Patent agents can help you get a patent. They've passed the patent bar and are registered with the USPTO, but they're not attorneys, so they couldn't represent you in court, but they're generally less expensive than patent attorneys. Trademark, copyright, and trade secret attorneys are not required to be registered, but it's probably a good idea to get one that specializes in those areas. Excuse me. You can also go to your local bar association to look for attorneys to help you get IP. There are some free legal resources for intellectual property because using an attorney for IP can be expensive. The Pennsylvania Patent Pro Bono Program, here's the link to that can help you get patents in Pennsylvania. It says patents only, however, they will help with trademarks if you're an artist, because it's from the Pennsylvania Volunteer Lawyers for the Arts. Philadelphia VIP Here's their website. The business must be within Philadelphia. They want you to be an LLC or be incorporated before they could help you with your intellectual property. But if you need help doing that, they can help with that too. There are income requirements unless you're a nonprofit, because they want to save the help for the people that need it the most. Same with the Pennsylvania Patent Pro Bono Program. They want to save the help for the people that need it the most. The University of Pennsylvania will twice a year in August and January accepts applications to become clients. You would have a student attorney supervised by a professor, and you would become a client of theirs. You still have to pay the fees, and that's true with any of these ones that have free or reduced fee help. The legal help would be free, but you still have to pay the fees to apply. Also, we have office hours 4 times a year with the University of Pennsylvania Law School. We have the next session coming up on March 31st. It's filling up quickly. They only have 8 spots. So if you're interested, apply. They're going to offer it again in the fall. And also in August to actually become a client of theirs every August and January. And there's also law schools throughout the country that have free legal help. Some of them are have restrictions geographically, like the University of Pennsylvania wants you to be in Pennsylvania. And some of the other law schools have those requirements, but some don't. And they'll help people throughout the United States, depending on what kind of help you need. Okay, unfortunately, I have to talk a little bit about scams. The USPTO advises to always check out the reputation of invention promoters or any requests for money. Be aware that requests for fees for patents and trademarks will only come from the United States Patent and Trademark Office in Alexandria, Virginia. Unscrupulous people may try to take advantage of you and either charge you a lot of money for things you could easily do yourself for free. They might actually outright steal your money, or they might not get you the type of intellectual property that will be most useful to you. I had one man tell me that he spent about $10,000. He got a patent, but it was a design patent, and what he really should have gotten to make his invention saleable was to get a utility patent, and that wasn't what he ended up getting. Here's some additional links that we talked about today. Here's some helpful books about intellectual property that can help you. These are available through the Free Library of Philadelphia or your local library, or you can purchase them at some place like your local bookstore or Amazon. If you're interested in licensing your invention or assigning it, that means you turn over your patent rights to someone else in exchange for royalty payments. This one Simple Idea, is a good book. Also this one, Profit from Your Idea, How to Make Smart Licensing Deals. This one, Patent Pending in 24 Hours, is about provisional applications for patents. This one talks about intellectual property in general. And this one, Patent It Yourself, is really like the patent Bible. It's really an amazing book that walks you through the process and is very helpful. Okay, so thank you for attending our presentation. Here's our contact information. I wish you every success, and I hope to see you at a future event for the Free Library of Philadelphia. Thank you for coming. Thank you, Jillian, for being my co-host. And I see we have a question here. Oh, thanks. Well, thank you. I appreciate you coming. I hope to see you at another event. You can send an email to brick@freelibrary.org. You can go here to freelibrary.org/patents, which is the web page for the Patent and Trademark Resource Center. Here's some other contact information. So here's our phone number. And I hope to see you again at a future event, and I wish you every success. Okay, thanks, Jillian. All right, I'm just going to wait one more minute, and then we'll sign off. Thank you for coming. Bye, thank you.